Welcome, everyone. Welcome to the May Compliance Corner, where once again, Scott and I will walk you through a number of different items that have been recently released this past month by our federal agencies. And similar to last month, we once again have a whole host of things to walk you through, which you'll see on our next slide, kind of touching on a number of different agencies this month. First up, we'll be talking about a long anticipated court case that we've been waiting for regarding the CFPB. And then as a result of that CFPB court case, there has been an interim final rule issued and some other considerations that we'll be watching now in related court cases that Scott will be mentioning here briefly. We also have a interesting inquiry by the Bureau looking for some information about fees related to residential mortgage transactions that we'll talk about. Also this month, we have two different interagency items. One is a new proposed rule related to the Dodd-Frank Act about incentive-based compensation agreements. And then we actually have an inflation adjustment to our Reg CC dollar amounts, what we'll talk about. FDIC has issued a report about some recent risks that they've identified to keep in mind. We have FinCEN that has issued a request for information about CIP now being something that registered investment advisors need to implement. And then HUD, we actually have two things from HUD, something related to the reporting of a cybersecurity incident and also new reconsiderations of value components. And then similarly, reconsideration of value by Freddie and Fannie and new loan modification information. So we've got a lot to cover. And with that, I'm going to turn that on over to Scott to walk us through the court case information.
Great. Thanks, Heather. Yeah, and as Heather had mentioned, long-awaited court case here. And just this month, the Supreme Court did issue its decision regarding the constitutionality of the CFPB's funding. And so, long story short, no, CFPB is not going away. And we had anticipated, regardless of the ruling, regardless of what the court had come down on this issue, that CFPB would be around in some form or another. But the case still carries some implications, right? That decision, of course, carries implications regarding the constitutionality of CFPB, given everything else that Heather had mentioned, the other cases, of course, that had hinged upon it. But really quick, just a little bit about the case, because it is important and relevant to just look at the issue at hand here. This is, of course, essentially looking at the extent of control of government agencies, here specifically CFPB, and the control that CFPB has and the control that the director has of CFPB. And so as a bit of context, agencies, of course, receive their authority from Congress. And that way, CFPB is funded by the Federal Reserve, and CFPB is also funded in that regard directly by request from its director. So the issue at question being whether that structure is constitutional. The matter being, given the fact that the director has that control over the agency's budget rather than Congress. Again, understanding this principle that agencies receive all of their authority from Congress. So the discussion in the case is very interesting, and it comes down to an interpretation, essentially, of the Constitution's Appropriations Clause, right? The issue being whether the CFPB's funding structure is constitutional, given where that authority must come from, given where its funding must come from. But for purposes of this conversation, our Compliance Corner, we'll leave that scholarly conversation out as much as we'd like to get into it, and Heather and I and others certainly on this call do find those matters interesting, but we'll focus on the takeaway here being that the court did find that the agency's method for funding is appropriate. So now then the question becomes, what are the implications of this? What are the implications on the ongoing court cases? So recall that we have cases regarding, of course, 1071, right, is probably the one that's front and center on everyone's mind. The Texas court case, right, that we've been talking about, but don't also forget credit card late fees and UDAP aspects of discrimination and the definition of unfairness. And so we have all that laid out on the slide here. You can see in the additional bullet points of the impact on this, because all of these issues in these cases had been suspended here pending this Supreme Court decision that we now have this month. So that main implication being that those stayed cases and evaluation of these issues can now continue given that CFPB's funding is constitutional. So those cases that were holding up certain CFPB activity or other issues, implementation of rules, because they were stayed or otherwise there were injunctions outstanding, again, pending this decision, can now proceed and will now proceed. And the challenge to 1071, for example, resulted in a stay based on the question of CFPB's constitutionality. It was, of course, a question and issue of the merit in that case. Now that that's been resolved, that case can now resume, and the courts will now need to consider the additional arguments against 1071 as that matter has been resolved. Again, the takeaway now being kind of that final bullet point on this slide, which we've isolated, right? Because it's important that we'll likely now see more activity from CFPB. Not only that this has been resolved and CFPB's focus will resume elsewhere, but because of the implication that this case carries in those other matters, 1071, right? And the court's decision this month now means that CFPB's final rule limiting credit card late fees can now proceed, and the rule will likely go into effect, as well as the challenges to UDAP definitions. We may see other actions, and again, we of course have to see how the other merits in the 1071 case will fare, but anticipate that CFPB will now go forward with its other priorities. Again, significant there regarding that decision, bearing in mind the implications that it carries. Now,
I would just add too, real quick, Scott, that just to point out for our members that those underlying cases that Scott had mentioned, those the issues at hand there are not related to CFPB's funding structure. They actually have their own separate merits that Scott was mentioning. Primarily being that did the CFPB act within their authority that they have to promulgate the rule that the way that they have promulgated, or to create an exam manual with a new definition in the way that they did. So the bulleted items here, these cases that we've been watching and Scott mentioned, the merits there are, did the CFPB go beyond the scope of their authority? Were they capricious? Were they arbitrary? Did they actually go through the administrative rule-making process when it comes to the exam manual? So there are some more technical components which are unique from the CFPB's funding structure. Although there was that component of the funding structure piece, there's still a lot of law to decide in those other underlying cases too. So just wanted to add that in, Scott.
Yep, of course. Thanks, Heather. So still more to consider, still more to come, even though we have this one matter resolved. So a specific implication from that decision here on our slide 4 here regarding 1071 compliance dates. So this one is pretty straightforward. CFPB issued a final rule regarding the implementation timeline of 1071. And this extends the compliance deadlines. What this comes from is the Texas court's order, right? So remember what we've discussed in previous months regarding the stay that was issued. And the court essentially said that we're going to have the stay pending the decision in the previous slide, right? Constitutionality of CFPB, as we're waiting to see where the Supreme Court comes down on that. But regardless of where that comes down, we need to do something about this time period, right? And so the court said that if the Supreme Court does decide that CFPB's funding is constitutional, that the rule then does need to be extended to compensate for the stay period where we had this wait. So, result of that, CFPB has issued the interim final rule to extend the compliance deadlines accordingly. And you can see the new dates on the table on the slide here. There's, of course, a link in the description below where you can find this item to CFPB's site, and you can find more info and links to the corresponding rules. But you can see the dates are outlined nicely on this table as well. With that, I will turn it over to Heather on the next slide.
All right. Well, we wanted to also mention that the CFPB has recently posted something that they are seeking information about mortgage closing costs. I think we mentioned this briefly last time we talked, that the CFPB had issued a blog, and they were talking about quote unquote junk fees in mortgage related transactions. And our little spidey senses went up and thought, well, gosh, we wonder whether or not there's going to be new activity in this particular genre. And it looks like CFPB is starting to do that work. And so just earlier today, there was a release by the CFPB asking for information from a broad scope of entities and people, as you see there in our bullets, looking for what their thoughts are about closing costs. And so we'll be talking here in-house about how to respond to that as participants of the industry, basically sharing the fact that we are just passing on the costs that are imposed in the actual closing situation, the cost of a consumer report, the cost of title work, et cetera, to try to provide information to the CFPB on this new request. We also wanted to make sure that you were aware of an interagency proposal. As I mentioned in the intro, this is a Dodd-Frank Act provision. So this is something that we first looked at back in 2016 when we had an incentive-based compensation rule, which structured how we could pay staff. And so now that we've had a number of years gone by, the agencies are once again looking to brush off that particular provision of the Dodd-Frank Act and look to see whether or not there needs to be something new added to incentive-based compensation agreements. So this is going to be a proposal that is going to be applicable to our larger institutions, that being with institutions that have $1 billion or more in average total consolidated assets. So it's kind of an interesting threshold there. So it's again, average total consolidated assets. And then within that first benchmark, they have 3 different levels based upon even further billions. And so we've got that there listed for you. And some of the prohibitions will be applicable across the board to all 3 different levels of organizations, that being certain types of prohibitions against the types and the features of these arrangements. And the purpose is to encourage less risky types of incentive arrangements. And then for levels 1 and 2, there will be additional requirements when you're looking at compensation arrangements. Also for levels 1 and 2, there'll be board of directors or committee oversights. There'll be certain record keeping requirements, as well as disclosures to the regulators for those higher asset institutions. So more to come on that. It has not yet been published in the Fed Register, but we wanted you to know that that interagency proposal came out and that we will be certainly commenting. So let us know if you have specific thoughts or concerns about that particular proposal. We'll be talking about that more between now and I believe the 60-day time period for the comment period. We also wanted to make sure that you were aware of an interagency proposal on the next slide with the CFPB and the Fed as it adjusts the Reg CC thresholds. As you can remember, several years ago, there was an inflation adjustment added to it, and they have upped some of these routine dollar amounts that we work with quite often when we're handling our deposits by our customers. So this particular rule is going to be effective July 1 of 2025. And with that effective date, you will see some increases. The next day availability will be going from $225 up to $275. The cash withdrawal underneath 0.12 of Reg CC is increasing from $450 to $550. And then the exception hold under 0.13 is going from $5,525 to $6,725. So I'm sure many forms vendors are in the midst of making some revisions appropriately. I know FIPCO is looking at this right now as well, but we wanted to make sure that you were aware that there will be some changes here. So procedures will need to change, staff awareness will need to be changed, and then some hold information disclosures will need to be changed. So the rule has been provided for you in the information below. Also, provided for you is a link to FDIC's 2024 risk review. And we included this particular item because we find it to be helpful of what FDIC has identified as being risks to financial institutions. And so as you can imagine, going through the report, there'll be a full breadth. There'll be the overall market risk. There'll be a snapshot of how the industry as a whole is doing. Then they go into credit risks, they go into operational risks. They've identified cyber risks, they've identified crypto risks. So the various different segments of the businesses that we offer in our financial institutions have identified different risks. And we find that to be helpful because when we identify the risks that FDIC has identified, we then can anticipate what their examiners are going to be looking for. So once they've identified a certain credit risk, you can anticipate that examiners are going to be pinpointing those risks into your own organization and asking questions related to that. For example, crypto assets. Are you involved in crypto assets? Are you working with third parties in crypto assets? And they'll then gauge their examination focus based upon answers of yes or no to an identified risk. So helpful to read through that report to again understand what FDIC has identified as being risky. We also wanted to make sure that you were aware of a recent ask by FinCEN, recently published in the Federal Register, the desire to expand Customer Identification Program or CIP programs for registered investment advisors. I think many of us being in the industry for a long time, we recognize that's a kind of a area that we're not surprised to see there being a CIP component added to as that area of the BSA rules have continued to grow. But we wanted to include it because many of you have shops that you are partnering together with registered investment advisors, either as a subsidiary or as a standalone service. There is a component within that information piece that looks to allow for the registered investment advisors to partner with a financial institution and piggyback off of financial institution CIP efforts, so long as there are some conditions met within the information piece. So take a look at that because you might be receiving inquiries from your registered investment advisor company or partner to see whether or not there can be some efficiencies of compliance and complying with that rule. So once again, sharing the information from an FYI standpoint. So Scott, what else do we have?
Just a few different HUD and secondary market items here to cover. So as Heather had said in the intro and the summary, a couple mortgagee letters and selling guide updates for Fannie and Freddie. So the first one, we'll start on the top left here with HUD FHA related items. And the first one we have is that HUD has issued a mortgagee letter, and this relates to reporting requirements for cybersecurity incidents. And so the letter does define a cybersecurity incident or a cybersecurity event that, in short, potentially jeopardizes the confidentiality of information security with the potential to impact a FHA-approved mortgage or otherwise would impact a mortgagee's obligations under the program. Now, I'm paraphrasing that a little bit just to give you the general context of what it's going to cover. The fuller scope of the definition is within there, but in general essence, that's what it's going to apply to. For FHA-approved mortgages, then, a mortgagee does experience a suspected cyber incident, it must be reported. So the first step would be reporting, and that's got to go through HUD's FHA Resource Center, which has its own email, and HUD's Security Operations Center, which has a separate email. The mortgagee letter outlines a whole host of specific information that needs to be included when that report is made. So make sure to take a look at the link. You can get the exact emails, the 2 email addresses where that report needs to be made to, and the exact info that needs to be included in that report. The second mortgagee letter that we have directly below that one relates to reconsideration of value. And we have 2 concepts on reconsideration of value. So what you'll see after we talk about this, Fannie and Freddie have as well. So we've talked about this concept of reconsideration of value and borrower-initiated ROV requirements. And this letter updates a few different things with regard to appraisals. So it does make some overall adjustments to appraisals as well, and the concept of what constitutes a material deficiency. So that kind of flows into ROV because that concept relates to how a ROV request is determined. And so that is expanded a little bit to include those within an appraisal, meaning a deficiency, what a material deficiency is, that indicate a potential violation of fair housing laws or non-discrimination standards. There's also some language that's added about foregoing communications with an appraiser, about a material deficiency, among certain other appraisal requirements. And then again, this flows into the ROV content, specifically procedures required for adding borrower-initiated ROV requirements. Again, this is the process we've talked about of how to respond to a borrower's request for reconsideration of value if they believe, for example, that bias was involved. So that process does include disclosure to borrowers that they may request an ROV, how they may do so. So instructions, if they so decide, there needs to be training implemented in order so that lenders and others can recognize bias, how ROV requests are processed, and the standards for responses to those ROV requests. And again, similarly, on to the next bullet, Fannie and Freddie have updated their selling guides to include borrower-initiated ROV processes as well. And so, again, very similarly in this regard, lenders need to implement policies and review and respond to requests for ROVs, including, again, borrower disclosures, instructions. This needs to be done at time of application and upon delivery of the appraisal report as well. Just the last letter here is an update to flex modification terms. So this is a loss mitigation modification option, the terms of which must be determined in accordance with specific requirements. And so the update here is to the steps for determining the terms for modification, which look to target a 20% principal and interest payment reduction, which includes revised expense to income calculations and evaluation process. Again, if that's a loss mitigation option, that is something that is explored by your borrowers, that process has been updated for those calculations. So make sure to take a look at that. Again, those 4 items, those links are included to each in your description below. If you'd like to know more, either on the cybersecurity responses or again, the ROV process, and specifically what is going to be required for those FHA-approved mortgagees or for Fannie and Freddie's within their seller guide, what their expectations are. Make sure to take a look because that comes directly from their process. With that, we are going to look to wrap up this month's Compliance Corner. And as always, we just like to remind you of the resources available on the WBA website. Always make sure to keep an eye on that, as there is a great host of compliance tools, resources, publications, training opportunities. Of course, as always, the WBA Compliance Hotline, where you can email, call. Always happy to talk about any of these topics or others that may come up. And if you're looking for any training, be it on a specific topic, be it on an area of law, new, old, refresher, any type of training that you're looking for, make sure to consider that WBA Legal In-House Compliance Training, where myself and Heather are happy to work with you to come up with a training program. And then don't forget the other areas on our website, areas that you can get involved, either with the WBA committee or section. Check out our best practices library. You can see the great resources that those committees and sections have created, and advocacy, and how you can get involved in advocating for the banking industry and the various opportunities available there. Thank you, everyone. We look forward to talking to you next month.